Welcome back to the Dershow. Today, the Constitution suffered another serious body blow, and former President Trump's rights to a fair trial have been all but negated. The trial judge in D.C., who has shown incredible bias against Trump, she trained at a firm which is highly democratic and also has a reputation for corruption and skirting the law. Not somebody who I have a lot of faith in her ability to conduct a fair trial. She rendered a ruling today saying that Donald Trump must be brought to trial the day before the primaries in the United States on March 4th. That's just about 6 months from today. It's impossible for him to get a fair trial in 6 months. It's just impossible. I'm as good a lawyer as defends criminals in these areas. I couldn't do it. I couldn't begin to do it. Let me just give you a little bit of arithmetic about it. So today, the government stated that it had already turned over 12.8 million pages of documents. 12.8 million pages of documents. There's no doubt in my mind that the defense has probably gotten millions of pages of documents on its own that have not been turned over by the prosecution. Let's assume, for argument's sake, that all in all, there are 14 million pages of documents. That's just a million, 0.4 or so more than what the government has already turned over. Let's assume that's the case. And let's assume that there are 180 days left before the trial. Just do the arithmetic. If you divide 12.8, that's the government's turning over, by 180 days, that means that Trump's lawyer will have to read approximately 71,000 pages a day. If it's 14 million documents, it would be 77.777 documents per day. Even artificial intelligence would have a hard time doing that. It is inconceivable for any human being. And I am a very fast reader and writer. I've written 52 books. I've read, I don't know, thousands and thousands of books. I read and write for a living. I couldn't come close to doing that. The most I could ever read on a given day, and I read this all the time because I'm an appellate lawyer and people present me with 10,000 page transcripts, sometimes 20,000 page transcripts, and skipping and finding relevance and not reading every word of every page if I see it's not relevant. The most I can ever do, is maybe 1,000 pages a day. I can't do more than that, and I'm pretty good at it. I can't read more than 1,000 pages a day and understand what I'm reading and provide an adequate defense. But the idea of 77,000 pages in a day, I haven't done the arithmetic. You can do it while you're watching the show. How many pages a minute does that amount to if you're working 12 hours a day? It is an inhuman task to put a defendant and his legal team, even if he has a legal team, and the Constitution doesn't provide for legal teams. If a person can't afford a lawyer, he gets a single lawyer. And Donald Trump, has a lead lawyer and probably, 2 or 3 other lawyers or legal assistants. But I have to tell you, when I do an appeal, I read every word of the transcript myself. Yeah, I trust my young associates, but I'm the responsible lawyer. I want to read every word of every document if I'm going to try a case, if I'm going to be the responsible lawyer. Obviously, if I'm of counsel, if I'm just consulting on a case, which I do more and more often now, I just read the parts of the record that are relevant to my consultation. If I'm a consultant on the First Amendment, I only read the free speech parts of the case. It started that way a long time ago with me. There was a case involving teleprompter back in 1973, and I was retained by Robert Fisk, great lawyer, the former Deputy Attorney General of the United States, former Special Counsel, former U.S. Attorney, probably the most eminent living lawyer in America today. He's in his 90s. He retained me to do a small part of a big case. The big case had to do with telecommunications and all of that, but there had been an indictment and a conviction. And I was a part of the appellate team, but I had a very small role. My role was only to see whether or not it would be was constitutional for the grand jury in the case that indicted him to have eliminated people between the ages of 18 and 21. So I wrote 4 or 5 pages on that and submitted it and said, all right, how do I designate myself on that? Well, I asked Bob Fisk and I asked a leading expert on legal ethics, and they both said, well, just sign off as of counsel. That means that you're just a consultant and advisor to the lawyer and to the firm. You're not responsible for the whole case. But when I am counsel, when I am the responsible lawyer, when I'm designated as lead counsel, I have to read every word. I can't leave it to an associate. I have won cases on issues that were buried back in the early days. I won a case, multiple murder conviction, because I found an issue that nobody had seen before. And I could have easily missed the issue. I had another case where I didn't see the issue, but it was called to my attention by an associate. I went back then and I read it, and I felt terrible that I hadn't seen the issue. But a responsible lawyer has to read every single word of discovery. What if you skip 100 pages and the smoking gun is in those 100 pages? Remember, those pages, those 12.8 million pages are turned over. They're supposed to contain exculpatory material that helps the defense, either Jenks Act material or Brady material. These are all technical terms. But how can you not read every word that the government has already read and has turned over to you saying, this is material that could help you win your case? Of course you're going to have to read that. This judge just acted so unbelievably irresponsibly, and the government acted irresponsibly. The government actually asked for a trial on January 2nd. That would have been 4 months and 3 weeks after the indictment. That was too much even for the judge. And so the judge moved it up 8 weeks just to tip her hat to the government and cover her own rear end. But denied Trump's motion to set the trial later so that he would have sufficient time to read all the discovery material. And then the judge made a fundamental error, repeating an error that the prosecution made. They both said essentially that the government has a legitimate interest in a speedy trial. No, they don't. The government has no interest in a speedy trial. The government has only an interest in a fair trial. The Constitution specifies that the defendant has the right to a speedy trial, not the government. The defendant has the right to a speedy trial. And if the defendant prefers a fair trial that might take longer to a speedy trial, that's his right. What's the government's interest? Oh, obviously, the government's interested in making sure that the trial doesn't get postponed for a year or 2 or 3 or 4 or 5. Yeah, all right, that's one thing. But the idea that this is the government's interest that has to be vindicated by the court, no. It's the defendant's interest. The defendant has 2 interests: speedy trial, if he chooses to have that. 2 of the defendants in the case in Georgia have already moved for a speedy trial, and the judge had no choice but to grant it. The defendant has the right to move for a speedy trial. But if the defendant says, no, I waive my right to a speedy trial, I want a trial which gives me and my lawyers enough time to review all the documents, that's his right too. Judge Shurkin, go back to law school. Learn what the Constitution means when it talks about a speedy trial. Don't invent a right that doesn't exist. That's judicial activism at its worst, and it's judicial activism designed to deny a defendant the defendant's absolute right. Now, I've gotten a lot of emails already on this, and I'll preview them. I'll read some later, but I'll preview them. A lot of my emails ask the following question. They say, does Donald Trump have the right to appeal that date? And the answer is yes, he has the right not to appeal, but to take mandamus, or what's called an interlocutory appeal, to try to bring the matter in front of the appellate court, in this case, the DC Circuit Court. And he's going to do that. He's already announced he's going to appeal. That doesn't mean that the court will grant the appeal. Courts have a lot of discretion to decide whether to grant interlocutory appeals or writs of mandamus that occur before the end of the trial. Most appeals, as you know, again, you know I'm an appellate lawyer, most appeals occur only after there's been a conviction. There can't be an appeal if there's an acquittal, because the government has no right to appeal. It's only a right the defendant has. I mean, Judge Chutkan probably will invent the right of a government to appeal, because she doesn't see this through the eyes of fairness and justice. She sees it through the eyes of Get Trump. And so the defendant has that right, but courts of appeals are reluctant to intrude before the trial is over. What they say is, look, wait until there's a conviction, plenty of time then, and then you can appeal it. And if you were right, we'll reverse the conviction. By that time, the defendant might have served a year or two in prison. But that's okay. The courts say your rights will be vindicated ultimately in any event. Now, I don't think Trump's going to prison pending appeal in his case. You never know with Judge Chutkan. You never know. But that's not good enough. He has the right to a fair trial, not just a right to appeal from an unfair trial. He has the right to a fair trial. This is especially so in this case. Why especially so in this case? Because the government has a strategy in this case. The prosecutors have a strategy in this case. The strategy is to get a down and dirty conviction, unfair one, just rush to judgment. They wanted a trial in January. That's how irresponsible and unethical, in my view, they are, seeking a trial in January. My opinion, that's unethical for a prosecutor to do. Prosecutors are supposed to be trying to do justice and have fair trials, not supposed to just take advantage of a judge who they know, or a venue which they know is highly biased against Trump. So the government's goal is to get a quick trial and a quick conviction, because in the District of Columbia, they'll get a conviction. A petty jury in the District of Columbia, comprised of 95% of people who voted against Donald Trump, and probably 70 or 80% who hate his guts, there'll probably be a conviction. And then the question is, will there be an appeal, and will it reverse the conviction? Let's assume it does. The conviction will occur during the height of the primary season, before the general election. Its intent would be to influence the election, and the reversal would occur months after the election was over, and we'd have either a new president or the same president. Now, the judge has said over and over again, and I challenge her to look me in the eye and say that, oh, I'm treating Donald Trump like any other defendant. No, you're not. If it were any other defendant, you would allow the trial to take place in a year, in 14 months, in 16 months. I bet if you look back at your own track record, you'll see that you give delays over and over again. All judges do, particularly when you have busy lawyers. It's because it's Donald Trump, and because you want to influence the outcome of the election. It may backfire, by the way. I think a lot of these prosecutors and judges are helping Trump. That doesn't make me happy. I'm not a Trump supporter. I don't want to see Trump elected. And so I'm opposed to what's going on for two reasons. One, it's helping Trump. I don't like that. Much more importantly, it's hurting the Constitution. I care deeply, deeply, deeply about that. And that's why I'm fighting back. I'm not fighting back on behalf of Mr. Trump's election fortunes. I'm going to vote against him. You folks can vote for him, vote against him. That's your right. That's not why I'm as angry as I am about what this judge has done and what the prosecutors in this case have done. I'm angry because this get Trump mentality, wrote a whole book about it, get Trump. And in the book, I predicted all this. I predicted the 4 indictments. I predicted that there'd be attempts to try the case before the election. And all of that has come true because it was so obvious. It was so predictable. It's so apparent what these prosecutors are doing. They're trying to influence the election. And this judge is trying to influence the election by saying she's not trying to influence the election. But she is. She's treating Trump absolutely differently from other defendants. And I bet you go back and you look at cases in the District of Columbia, you look at comparable cases in terms of complexity, in terms of seriousness, in terms of number of pages turned over during discovery. All right, a challenge to the judge and to the prosecutor. Find in which the government has turned over 12.8 million pages of documents that has been tried in 6 months. You show me that case. I challenge you to find it. You're not going to find it. Because if there were such a case, it would be reversed on appeal. And I think this case will be reversed on appeal. The lawyer for Donald Trump has already said, I cannot try this case. And as I've told you before, if I were the lawyer, I'd refuse to. I'd walk out of the courtroom. I'm sorry. I'm not doing it, just like I would refuse to perform an operation on a heart or brain patient if I didn't have the adequate preparation time to do all the tests. I'm not doing a brain surgery without a CAT scan. I'm not doing heart surgery without all kinds of tests that are required to do that. I'm just not doing that. My job as a doctor is to save life, not to take life. And my job as a lawyer is to protect liberty and protect constitutional rights, not to allow the judge to violate constitutional rights, is what the judge is doing in this case. So I hope Donald Trump will appeal this outrageous decision to have this case tried in 6 months. And I hope the appellate court will say, no, wait a minute. You just can't do this. You have to take into account the number of pages. You know what the prosecutor said in this case? The prosecutor essentially said, no, your lawyer doesn't have to read every page. They can just skim it, just skip through it. Do you want a doctor who skims through the medical reports? Do you want a lawyer who skims through the exculpatory evidence, the Brady and Jenks material? That's not a lawyer I would hire to be one of my associates, and it's not the kind of lawyer I would ever be. So, Your Honor, sorry, I am not going to try this case. You want to appoint another lawyer? You appoint another lawyer, but I'm not walking into this courtroom and committing malpractice. You can't make me do that. You can't make me commit malpractice. You can't make me give my client the ineffective assistance of counsel. That's not my role. My role is to vindicate the Constitution, not to undercut it because you want to bring this case to trial quickly because you think the government has an interest in a trial within 6 months. No, the government doesn't. There's a sign in front of the Justice Department that basically says the Justice Department wins when justice is done, regardless of whether or not the defendant is found guilty or innocent. That sign has been covered over with mud. And now all that matters, the sign that should be put up in front of the Justice Department now is, get Trump by all means, at all costs. The Constitution be damned. Get Trump. That's the new motto of the Justice Department. Get Trump. And this judge is part and parcel of that phenomenon. Now she's going to say, well, but I didn't grant the government's motion. The government absurdly, unethically wanted this motion to be granted, having the trial on January 2nd. That is what, September, October, November, December, 4 months from now. She turned that down, saying that was too soon. But she then granted it essentially by saying, all right, but I'll give the defendant another 2 months. So maybe they can read another 10,000 pages out of the 14 million. Not enough. Not enough. A March 4th trial date is unconstitutional. A March 4th trial date violates the defendant right to due process and a fair trial. And so let's wait and see. Let's wait and see whether or not this is going to be appealed. I hope it's appealed. I hope the Court of Appeals reverses it. I hope the Court of Appeals rebukes the judge and perhaps takes the case away from the judge. I think the defense should also move for a change of venue out of the District of Columbia, where he cannot get a fair trial, to a more purple area. Some parts of Virginia or West Virginia might be appropriate, or even some parts of Maryland, which is a heavily Democratic state, but not close to what's the situation in the District of Columbia, 95, 96% anti-Trump. You just can't get a jury of one's peers in a district like that. And the judge is probably going to rush the case. She's probably not even going to give the defense an opportunity to question jurors and do voir dire. She'll probably do what a lot of other federal judges do: say, I'm going to ask a bunch of questions, and but they'll tell the truth. And all I'm going to ask them is, do you have an opinion on his guilt or innocence? Oh, you do? Could you withhold that opinion and not have it influence your decision? Oh, you can? Fine, you're seated. That's the kind of voir dire we see these days by a lot of federal judges. In the state court, it's very different. In the case now in Fulton County, I'm told, I don't know this personally, but I'm told there's a case now which has been in jury selection for months and months and months, much less complicated than the Trump case. And so I suspect the case in Fulton County, the verdict will not come until after the election. But again, who knows? Everybody's rushing to judgment. Right now, listen to the absurd situation we have now. Right now, Trump is faced with 3 criminal trials within, I think, 2 weeks or 2 or 3 weeks. There's one on March 4th. There's another one in mid-March. There's another one as well in March. And the fourth of the 4 cases is in May. So you're asking his lawyer to prepare for 4 of the most significant cases in modern American history to be conducted within 6 weeks of each other. It's inhuman. It's unthinkable. It's what you would expect Putin would do if he were trying one of his opponents who was not foolish enough to get on an airplane. It's not American. It deserves another banana. So I'm now up to 6, folks. I'm up to 6 bananas. It's only 10. 10 gets us to Ecuador and to the Soviet Union. Russia, today, Putin, Russia, Syria, Iran, China. I didn't ever expect I'd get up to 6 bananas, but this today has brought me up to 6 bananas. I hope we don't get to 7, but we may. And if the Court of Appeals reverses, I'll knock it down to 5 or maybe 4. But we're in banana land, and it's a terrible thing. It's a terrible thing for all Americans. The defendant in the case will have his rights denied, but all Americans will have their rights denied because Americans don't have an interest in a speedy trial. Americans have an interest in a fair trial. And if a speedy trial cannot be a fair trial, the interest in a fair trial comes before the interest in a speedy trial. There are some questions, some very good questions today. What do I think of the fact that the prosecutors have said that the defendant doesn't need to review all the papers? Well, I've gone over that. Yes, he does. In fact, if the defense does not review all the papers and there is a conviction, there would be a claim for ineffective assistance of counsel. My God, you got all this discovery, this material that was exculpatory, and you didn't read it? You skimmed it, or you skipped thousands of pages because you thought it might not be relevant? How do you know what's relevant until you've read it? So again, the prosecution does not know what they're talking about. They don't have the experience that we as defense attorneys have in reading material and how you can come up with gems, diamonds, buried and often, by the way, this is an important point. Very often the prosecutor will give you more discovery than you want, because what it will do is it will hide the really relevant material in a large amount of irrelevant material, a needle in a haystack. If it has a needle and the needle is exculpatory, it will often give you a haystack. Ask any criminal lawyer. They'll tell you that. That's what prosecutors do. That's what unethical prosecutors do. That's what prosecutors who seek victory over justice do. But it's very common. Ask any criminal lawyer. They will tell you that prosecutors will often give you masses of material and hide in that material a small amount of exculpatory material. And so, of course, you have to read every word. Otherwise, you're going to be victimized by that prosecutorial trip. Ask any defense lawyer you know, and they'll tell you that's a common ploy that prosecutors employ in order to keep the defense from knowing it. And then if there's a motion after trial, oh my God, they didn't turn over this exculpatory material. The government says, yes, we did. You didn't read page 11,763 footnote 11. You didn't read that. There it is, as clear as day, buried in a haystack. There's your needle. You lose. That's what prosecutors say. I know that because I've seen prosecutors say that in cases that I've been involved in. And I've been involved in more cases than anybody wants to know. And so I know all the tricks of the trade. And that's why Judge Chutkin can't put it over on me. Maybe she can put it over on other people, but she can't put it over on me. I know enough about this to know what's going on here. What's going on here is a complete injustice. All right, there was a letter about how can we make voting machines more secure and less subject to possible criticisms for future elections. I'm not talking about past elections. Well, what's very important, and I've written this in a brief, what's very important is that when the government delegates to a private company a governmental function, counting votes, the private company has to live by the government's rules, not its own rules. It can't say we have business secrets. It has to be as transparent as the government would have to be. That's number one. Number two, I have proposed for a long time the appointment of an election commission. Israel has it, Britain has it, other countries have it. A group of extremely distinguished, nonpartisan, or at least bipartisan people, to whom any complaint about an election, machines not functioning, they're hiding votes, the polls closed too early, there's a butterfly ballot, there are hanging chads. It all goes to the election commission, not to a court, and not to a political party, and not to Congress. It goes to this election commission that can rule in real time. In real time. Had that happened in Bush versus Gore, the butterfly ballot might have been changed by 1 o'clock in the afternoon, and several thousand additional votes might have been cast for Al Gore. We don't know. We'll never know because it didn't happen. But I would like to see a commission appointed for the next election. I got a very nice letter saying, I enjoy your Socratic dialogues and your debates. I used to watch you with William Buckley, and I used to always root for William Buckley. Well, William Buckley was a great debater. I debated him on numerous occasions. I debated him in front of, I don't know, a couple of thousand people at Harvard, and probably hundreds of thousands of people on television on a range of subjects. And he always took the conservative point of view, and I always took the liberal point of view. Who won, who lost, was always in the eye of the beholder. But the one thing that everybody said is we had good and respectful debates. And most important, we had respectful debates. I admired William Buckley's wit and intelligence, and he admired my intelligence, probably not so much my wit. But and after the debate was over, we'd go and have a drink, and we would critique each other and congratulate each other on a good argument made. I remember saying to him, I never thought of that. You really persuaded me on that one. Today, is anybody ever persuaded by somebody on the other side? No, they can't be, because they just call them names. So not at all. I got another letter saying, I approve of your being such a principled person, but principles can be very expensive. You can lose your job. You can lose your friends. I know. I wrote a book about that called The Price of Principle, telling the story about what has happened to me and continuing to happen to me. Lawyers on the other side, rabid woke Democrats are coming after me, filing bar charges against me, making complaints against me, obviously writing letters. That's okay. Writing op-eds. That's okay too. But being a principled person can be very expensive. And the reason is because principles often go against your politics. I'm a liberal Democrat. I want a Democrat to be elected president, but that's my politics. My constitutional approach is to make sure that people who I don't want to see get elected are treated as fairly as people who I want to see get elected. So that's my message to you. Put principle over politics. Too few people are doing that. I wish Judge Chutkin were listening to me tonight, and I would ask her the same thing. Put judicial principles over politics. I don't think you're doing that today. All right, tomorrow we'll be talking more about the upcoming trials and whether or not the cases will be moved from state court to federal court. The judge should be hearing decisions, arguments about that today, and maybe we'll render a decision today or tomorrow. Maybe he has already, I don't know. But that's going to be a big issue because both Meadows and at least one other defendant have moved for a change to federal courts, and Donald Trump will certainly do the same. So see you tomorrow.